Hello, everyone. Welcome to Immigration Update Desk. I am your host, Alex Grant. We are tracking breaking developments across the United States about a sharp and historic escalation in immigration enforcement, one now reflected in a record-setting number of arrests and people placed in detention facilities with real consequences for immigrant families, legal advocates, employers, and communities nationwide. This number is not just a statistic, it represents a profound shift in how immigration enforcement is being carried out in early 2026. In this report, we take a deeper look at the breaking news surrounding ICE's record-high detainee population, how detention levels reach this point, what the current crackdown looks like on the ground, who is most affected by these arrests, and what this moment means for immigrants, families, and the broader U.S. immigration system. If you find this valuable, please subscribe to Immigration Update Desk, tap the bell, and like the video so updates reach your phone the moment they post. Timing matters when news is moving this fast. For the first time since the agency was created, U.S. Immigration and Customs Enforcement is reported as detaining roughly 73,000 individuals at one time. Multiple outlets citing internal Department of Homeland Security data describe a sustained rise that accelerated through late 2025 and into January 2026. What makes this surge especially significant is not only the number itself, but the speed at which it has grown. Only a year ago, ICE's detainee population was tens of thousands lower. Since then, arrests have increased, detention contracts have expanded, and new facilities, including county jails and temporary sites, have been brought into use to accommodate the growing population. In exceptional circumstances, military installations and emergency sites have been used as temporary holding locations, underscoring the scale of the expansion and the logistical challenge of housing, transporting, and processing so many people at once. Understanding these figures requires clarity about what detention means in the immigration context. Immigration detention is a civil, not criminal, process. It is used to hold individuals while the government determines whether they may remain in the United States or must be removed under immigration law. Being detained by ICE does not mean someone has been convicted of a crime. Many detainees are asylum seekers, long-time residents with deep community ties, or people who may still be eligible for relief from removal. Federal data indicates that roughly 2/3 of the current detainee population consists of single adults, while the remainder includes family units, meaning parents held with children in designated settings. ICE has stated that a portion of detainees have criminal convictions or pending criminal charges. However, a significant share of those in custody are held solely for civil immigration violations, not for criminal offenses. This distinction is crucial for understanding due process protections, court procedures, access to legal counsel, and the kinds of relief that may be available. How did detention levels reach this point so quickly? Several factors converged in late 2025 and early 2026. Enforcement directives broadened arrest authority and reduced the emphasis on narrow priority categories, allowing officers to place more people into custody regardless of criminal history or length of time in the country. At the same time, Congress approved additional funding tied to bed capacity, transportation, medical care, and contract oversight, effectively giving ICE the resources to detain more individuals for longer periods. With more beds available, field operations scaled rapidly. Fugitive operations teams conducted wider sweeps focused on people with final orders of removal, while at the border and in the interior, coordination between agencies increased transfers into ICE custody after initial CBP processing. The immigration court backlog compounded the problem. With millions of pending cases and a limited number of immigration judges, hearings are frequently scheduled months or even years in the future. Detention is often justified as a way to ensure individuals appear for hearings or are available for removal. But when courts are backlogged, detention periods stretch, increasing the average daily population even if the pace of new arrests holds steady. Behind these numbers are decisions about where and how people are held. The ICE detention network is a patchwork of dedicated facilities, contract beds in county jails, and intergovernmental service agreements with local governments and private operators. Facilities are supposed to follow published detention standards that address access to counsel, medical care, recreation, grievance procedures, and conditions of confinement. As expansion has accelerated, oversight has become more complicated. Advocates and some lawmakers report that access for attorneys can be inconsistent across facilities, that travel distances make in-person visits difficult, and that phone access can be unreliable or expensive for detainees trying to contact counsel and family. In response to audits and public scrutiny, ICE and DHS oversight bodies have highlighted inspection regimes, corrective action plans, and contract termination authority where repeated violations occur. Judges have emphasized in recent rulings that transparency is essential when the government deprives individuals of their liberty, even in civil proceedings, and they have pushed back on attempts to limit visits by elected officials or independent monitors. The debate over access and oversight is ongoing, and it is intensified whenever the detained population grows. On the ground, increased enforcement activity shows up in predictable places and times, at homes during early morning hours, at courthouses in jurisdictions where policies allow civil immigration arrests, at workplaces subject to separate employment compliance rules, and during routine check-ins at ICE field offices. Community organizations report that enforcement actions often lead to a cascade of urgent needs: locating a detained family member, finding an attorney, arranging childcare, securing rent, and preserving employment for the primary wage earner who remains at home. Children experience the shock immediately. Schools and social workers see the impact in attendance and stress. Employers lose staff without notice, and co-workers who witness arrests may seek guidance about their own rights and obligations. The ripples are wide. A single detention can trigger financial instability, housing insecurity, and long-term emotional trauma for entire households. Within the detention population, who is most affected? The profile is diverse. There are recent arrivals with pending credible fear screenings. There are longtime residents with U.S. citizen children. There are individuals with final orders issued years ago who are now seeing their cases revisited. There are people with criminal histories and people whose only violations are immigration-related. For asylum seekers, detention can coincide with a fast-moving series of interviews and legal deadlines. Credible fear and reasonable fear processes have strict timelines, and missing a deadline because of translation delays or limited phone access can derail a claim that might otherwise succeed. For longtime residents, the path may involve bond hearings, applications for cancellation of removal, waivers, or other relief that require evidence of community ties, good moral character, and hardship to qualifying relatives. Because immigrants in removal proceedings are not guaranteed government-appointed counsel, a growing share of the detained population faces complex legal procedures without representation, which lowers success rates and raises fairness concerns. The legal landscape within detention revolves around a few key mechanisms. First is the initial custody decision. Some individuals may be eligible for release on recognizance, parole, or alternatives to detention such as electronic monitoring or telephonic reporting, depending on the circumstances and the field office's policies. Second are bond hearings before an immigration judge for those who qualify. The judge considers flight risk and danger to the community and may set a monetary bond. Evidence that supports release can include proof of address, employment letters, school records of children, medical documents, and letters from community leaders. Third are the applications for relief on the merits, like asylum, withholding of removal, protection under the Convention Against Torture, adjustment of status where eligible, or cancellation of removal. Each form of relief carries its own elements and evidentiary burdens. Timelines are compressed in detention contexts, which means organization and preparation are critical. Because people ask what to do in the first 24 hours after a detention, here are practical, lawful steps that advocates commonly recommend in plain language. Families should try to obtain the person's A number, alien registration number, and date of birth to search the ICE online detainee locator, which can help identify the facility and confirm custody status. Once located, call the facility to verify attorney visitation rules, telephones, and mailing addresses. If you are seeking a lawyer, prioritize reputable nonprofit legal service providers or licensed private attorneys with detention experience. Avoid scams that promise guaranteed outcomes or request large cash payments without a written agreement. Help the detainee gather documents that may be needed quickly, such as identification, proof of residence, marriage certificates, children's birth certificates, school records, medical records, and letters of support. If a bond hearing is possible, assemble evidence of community ties and a sponsor's ability to provide housing and transportation. If the person fears returning to their home country, emphasize that they should tell officers clearly and request an interpreter in their best language. No one is required to sign forms they don't understand. Always keep copies of everything you submit. These actions do not guarantee release, but they position a case so that legal options can be pursued effectively. Alternatives to detention, often called ATD, deserve mention because they are part of this story. ATD programs include check-ins by phone, smartphone monitoring, voice recognition calls, and, in some cases, GPS ankle monitors administered by contractors through programs like ISAP. Supporters argue that ATD is more humane and less costly than detention. Critics argue about effectiveness and privacy concerns. Regardless, ATD decisions vary by field office and case type, and they may be available for people who present low flight risk and have strong community ties. If ATD is offered, read the program requirements closely and ask what triggers a violation, what to do if you miss a call, and how to update contact information. Misunderstanding program rules can lead to redetention. The rise in detainee numbers has renewed attention to detention conditions and medical care. Journalistic investigations and civil society reports have highlighted cases where care was delayed or contested and have called for stronger independent oversight. Federal officials state that standards are enforced, that deaths in custody are reviewed, and that corrective actions are taken where deficiencies are found. The larger the population, the greater the scrutiny. Scale amplifies both risks and the need for transparency. If a detained person experiences a serious medical issue, family or counsel can request medical records through proper channels, file complaints with the facility and with the DHS Office for Civil Rights and Civil Liberties, and, where appropriate, seek court intervention. In emergency circumstances, advocates may also contact consular officials from the person's country to ensure that international obligations are observed. This enforcement surge is happening against a broader political backdrop. Immigration has once again become a central issue in national debates, and enforcement-heavy approaches reflect philosophies that prioritize deterrence and control. Administrations change, but the practical effect on the ground right now is a system detaining more people, more aggressively, than at any prior moment in ICE's history. Policymakers and courts are watching closely to see whether detention levels continue to rise or begin to stabilize, A population of roughly 73,000 raises serious questions about cost, capacity, humanitarian standards, and long-term effectiveness. Detention is expensive and resource-intensive. Beds, staff, transportation, legal processing, and medical contracts strain budgets. Communities near facilities feel the impact, both in employment provided by facilities and in humanitarian needs when families are separated. The scale also pressures immigration courts, which must process more detained dockets on tighter timelines. For immigrants and families observing these developments, it is essential to remember what detention changes and what it does not. Detention does not erase legal rights. Individuals in ICE custody can still apply for asylum, request bond hearings where permitted, seek parole, pursue cancellation of removal or adjustment of status if eligible, and appeal adverse decisions to the Board of Immigration Appeals. However, detention makes every step harder. Reaching a lawyer is more difficult, collecting documents takes longer, finding witnesses is challenging, and language interpretation may be inconsistent. Preparation and rapid response are critical in this environment. Families should keep important documents in an accessible place. Create a list of emergency contacts, including at least one person outside your immediate area. Memorize or write down phone numbers since detainees may not have access to their cell phones. And explain to children in age-appropriate terms what to do and who to call. Employers who want to support affected employees should consult anti-discrimination rules around I-9 compliance, avoid demanding specific documents, and consider offering time off for legal appointments or court dates when feasible. Because fear spreads quickly and rumors can be harmful, we need to separate verified developments from speculation. Reports of widespread bans or blanket suspensions often conflate limited procedural pauses at specific posts with system-wide changes. When major policy shifts occur, they are announced in formal channels. Presidential actions, DHS press releases, State Department cables reflected in the Foreign Affairs Manual, or Federal Register notices. Before changing your plans based on something you read online, check a primary source or verify with a trusted legal aid organization. If a rumor turns out to be wrong, you will have saved yourself unnecessary stress. If it turns out to be right, you will see it confirmed in ways that spell out exactly what changed and who is affected, which helps you respond correctly. Let's talk about human stories, because numbers alone can obscure what families are living through. A father taken at 6 a.m. in front of his kids leaves behind a spouse who now has to keep the household running, juggle work, call the school, locate a lawyer, and find out where he is being held. A young asylum seeker who speaks a rare language may need an interpreter, and when one is not available immediately, deadlines keep ticking. A detainee with diabetes or asthma might need regular medication. Any gap between prescription and delivery becomes a serious health risk. A small business owner loses 2 key employees on the same day and must decide whether to delay orders or hire temporary staff who will need training. These stories are everyday realities when detention numbers rise. Community groups step in with food, rent assistance, rides, childcare, and mental health support. Faith groups mobilize. Attorneys work late nights to file bond motions or emergency stays. The system is designed to process cases. The community is what helps people survive the wait. In terms of personal readiness, there are respectful, lawful steps families can take without increasing risk. Keep copies of passports, birth certificates, marriage certificates, and prior immigration filings in a secure, accessible folder. Consider scanned versions in a secure cloud account so they can be shared quickly with counsel. If you have a power of attorney, keep it current and know how to use it to access bank accounts or sign leases if a spouse is detained. If you are the primary caregiver, identify a backup caregiver with written permission for schools or doctors if needed. If you move, File address updates with USCIS or the immigration court to avoid missing notices. If you have court dates, put them on multiple calendars with reminders and keep proof of any continuances. These are ordinary organizational habits, but in a crisis, they become lifelines. It is equally important to understand what to do if someone is taken into custody and you cannot find them. Start with the ICE online detainee locator using the A number or full legal name and date of birth. If no record appears, it may be because the person is still in CBP custody or because the system is experiencing delays. Continue checking every few hours. If you believe the person has medical needs or is a sole caregiver for a child, share that information with counsel so it can be raised promptly with ICE. If the person is a citizen of another country, consular officials can often help confirm location and may visit the detainee to ensure their rights under international agreements are honored. Throughout, keep a written timeline of who you spoke with, when, and what you were told. Accurate notes help lawyers and, if necessary, members of Congress who assist with case inquiries. The conversation about detention also includes the question of alternatives that do not involve custody. Community-based case management programs, pilot initiatives with local nonprofits, and enhanced check-in systems have shown promising compliance rates at lower cost than detention, especially for families and low-risk individuals. These programs are not available everywhere, and eligibility varies, but as detention numbers climb, policymakers are revisiting what mix of tools achieves compliance, fairness, and public safety. For people offered placement in such programs, understanding the requirements and documenting compliance, screenshots of check-in apps, records of calls, letters from case managers can be helpful if status is later questioned. Looking ahead, will these detention levels continue, stabilize, or recede? Much depends on court capacity, appropriations, and policy choices. If immigration courts receive additional resources, detained dockets could move faster, reducing average time in custody. If agencies continue to emphasize broad arrest authority, numbers may stay high. Litigation over conditions, access to counsel, and the legality of certain enforcement tactics is likely to continue. Courts will balance deference to executive enforcement with individual rights. Whatever the direction, families should plan for a marathon, not a sprint. Make decisions that keep you stable for months, not just weeks, and adopt a documentation routine that you can sustain. For those watching this who are not directly affected but want to help, effective support is practical and steady. Donate to local legal aid groups and community organizations that provide direct services, offer rides to court, childcare during attorney meetings, or meals for families handling multiple emergencies at once. If you are an employer, learn the rules around I-9 compliance and anti-discrimination so you can respond lawfully and humanely. Build cross-training into your teams so work can continue if an employee faces a temporary absence. If you are part of a faith community or civic group, coordinate with established organizations rather than duplicating efforts. Experienced groups know how to stretch resources and avoid gaps. As we close, let's be clear about the headline. The reported record-high detainee population, roughly 73,000, stands as one of the clearest indicators of how dramatically U.S. immigration enforcement has shifted in early 2026. It is a moment that will shape legal challenges, policy debates, and community responses for months to come. Yet it is not the only truth in the system. The immigration system still issues approvals every day. Families still win their cases, judges still grant bond, and people still reunite with loved ones after periods of uncertainty. The work for families now is to stay informed, get organized, know your rights, and respond quickly and calmly to any change in status. The work for communities is to provide steady help and hold institutions accountable to humane standards. The work for policymakers is to measure outcomes honestly, cost, compliance, fairness, and safety, and to adjust tools accordingly. That's all for this bulletin from Immigration Update Desk. Our channel provides the essential visa information and procedures you need for your U.S. immigration journey. It's important to understand each step clearly. Processing stages, application requirements, timelines, forms, fees, interviews, and how to avoid common mistakes. We will continue to cover U.S. visitor visas such as B1 and B2, work visas including L1A, L1B, and H1B, student visas, green cards, immigrant categories like EB1, EB2, EB3, EB4, and EB5, and family-based immigrant visas. If you haven't already, please subscribe to Immigration Update Desk and tap the bell so you receive timely, source-backed updates. Thank you for watching, and we'll see you in the next video where we will explain how to locate a loved one in ICE custody, how bond hearings work, and how to assemble a clean packet of evidence that immigration judges routinely find persuasive. Because in moments like these, clear information and calm preparation can make all the difference.